Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. A contract is a promise, the breach of which will result in a court granting a remedy for its non-performance. Contracts have a number of elements, basically offer, acceptance, and consideration, and then a number of other ancillary issues that come up in the course of a contract. But not all promises are a contract, and not all promises are equal. So let's talk a little bit about that. Some contracts are required to be in writing. This is something called the statute of frauds. You may have heard of this. It is a statute that requires certain contracts to be in writing and signed by the parties to be bound by the agreement. The purpose is to prevent fraud and other injury. The most common types of contracts to which the statute applies are contracts that involve the sale or transfer of land and contracts that cannot be completed within 1 year. Now, that doesn't mean that the contract has to be completed within 1 year. It simply means that if it can be completed in 1 year, then it's not within the statute of frauds, unless it involves the sale or transfer of land. There are entire books written on the statute of frauds, and we don't need to go into that here, other than to say that when an issue comes up in a case where something is not in writing that it should be, there are other remedies that can be used. So sometimes these promises are not reduced to writing, and the law recognizes some exceptions, and one exception is detrimental reliance. Detrimental reliance is also known as promissory estoppel. It's a legal doctrine that may be invoked in situations where one party or the other makes a promise and the other party relies on that promise to their detriment. In other words, if Party A makes a promise to Party B and Party B relies on that promise to their detriment, the court may prevent Party A from breaking the promise even if there's no formal contract between the parties. Here's how detrimental reliance generally works. There must be a clear promise by one party to another. This promise can be verbal, written, or implied through conduct. Reasonable reliance, the second party, the one to whom the promise is made, must reasonably rely on the promise. And that means reliance has to be there and justifiable under all the circumstances. And then the party relying on the promise must take some later detrimental action or make some change in their position based on that reliance. This action or change must result in a detriment to the relying party. And then injustice can only be avoided by enforcing the agreement. That's how the other element. It has to be something where there's just such great injustice that you absolutely have to enforce the promise. Because if the promisor were allowed to break the promise without consequences, it would result in unfairness or harm to the party who relied on that promise. Now, here's a case from Missouri that we talked about in another video a few days ago where detrimental reliance came into play, or promissory estoppel. How the court explains the doctrine and how it applies the doctrine are informative. Here's what the court said. With respect to count 3, Dr. Zipper undertook to plead a cause of action for promissory estoppel against respondents because he detrimentally relied on Mr. Kassif's promise to sell him the building if he made significant improvements. Missouri courts have adopted the Restatement Second of Contracts, which recognizes promissory estoppel as a cause of action based on detrimental reliance of one party on the other promise of another. The first subpart of Section 90 states, a promisor should reasonably expect to induce action or forbearance on the part of the promisee or a third person, and which does induce such action or forbearance is binding if injustice can be avoided only by enforcement of the promise. The remedy granted for breach may be limited as justice requires. The elements of a claim of promissory estoppel are 1. A promise, 2. Detrimental reliance on the promise by the claimant, 3. The promisor should have or did, in fact, reasonably foresee the precise action the promisee took in that reliance, and 4. Injustice can only be avoided by enforcing the promise. The remedy for promissory estoppel is specific enforcement of the promise. Promissory estoppel is rarely a successful cause of action, however. The doctrine of promissory estoppel should be used with caution, sparingly, and only in extreme cases to avoid unjust results. This is particularly true when the promise sought to be enforced falls within the statute of frauds. Only in the most extraordinary circumstances will promissory estoppel abrogate the statute of frauds. There is an understandable concern that to completely embrace the doctrine would totally abrogate the statute. Consequently, the case law direction is to proceed with caution and to apply the doctrine only to avoid unjust results. Turning to the allegations in Count 3, the elements of a claim for promissory estoppel were adequately pled. Dr. Zipper alleged that Mr. Cassif promised him that if he would renovate the Parkway Medical Building, MCI would cause its wholly owned subsidiary, the defendant MCP, to sell and convey the Parkway Medical Building to the plaintiff Zipper for the current fair market value of the property and give him credit towards said purchase price for the actual expenses which he incurred in renovating the building. Dr. Zipper alleged that after he relied on this promise and spent $125,000 improving it, they refused to abide by the promise to sell him the building. Zipper further alleged that it would be unjust for them to derive the benefits of the improvements and requested the trial court award him actual contract damages in the amount of $125,000. These allegations were sufficient to state a cause of action for promissory estoppel. The next issue, however, is whether there was sufficient evidence on each element of Dr. Zipper's claim to avoid summary judgment. And here's where it breaks down. The court says, essentially, that he has all of the elements pleaded or evidence for the first three elements, but not the fourth. Let's go down there. However, 3 of 4 elements is insufficient. Dr. Zipper's case is wanting on the fourth element, and whether the injustice can only be avoided by enforcing the promise. This element requires an additional analysis. According to the restatement, in determining whether injustice can be avoided only by enforcement, the following circumstances are significant: the availability and adequacy of other remedies, particularly cancellation and restitution. And here, ladies and gentlemen, is where the train runs off the track, because he does have another remedy, and that remedy is unjust enrichment. And indeed, that is exactly what the court determines, that because he has this other remedy for unjust enrichment, there is no need to specifically enforce this promise, and he had also waived specific performance in another case. So this is just another example of how when lawyers get together and they plead multiple causes of action, it's sort of like a Jenga puzzle. You have to be very careful what parts you leave in and what parts you take out. So that's what I have for you on detrimental reliance or promissory estoppel. Hopefully you found this interesting, helpful, useful. If you have any comments, please leave them in the comments down below. Like, share, subscribe, all that stuff we ask you to do. If you have the opportunity today, take a moment to be kind to someone. Do something nice for someone. Open a door, start their car, brush the snow off their windshield. Whatever it is, take a moment, be a nice person. Do your brothers and sisters in this world a favor by helping them out. If you have any questions, like I said, leave them in the comments. Otherwise, I'll see you back here tomorrow. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.